SJC-10046, Commonwealth versus Rakes.
Mr. Black, good morning.
If it please the court, Mr. Chief Justice. My name is Attorney Alan Black. I'm representing Mr. Rakes in this matter.
Before you get warmed up, why are we hearing an appeal 12 years after the trial?
A lot happened. First of all, some of the items that occurred were correspondence between my client and I that required a lot of time to go through. There's also a closure argument which we agonized over, I should say my client and I, and we waited for certain decisions to take place. As Chief Justice knows, there's a lot of courtroom closure stuff. Matter of fact, there's a case going on now in front of the Supreme Court that I
We are aware of that.
moved to stay this because of that. And well, without going into too much conversations between my
Oh, I
client.
don't want any conversation with the client. So
Yeah, I don't want to do that, but
simply
but
is, okay.
that's the reason.
Okay. You may proceed.
Thank you. This case, looking at this case, this case really brings out the problem and the unreliability with the co-conspirator hearsay statement exception to the hearsay rule. And it's an interesting case in that you have several witnesses testifying to things that a co-defendant told them related to the defendant. Defendant didn't testify, the co-defendant obviously didn't testify, it was a separate trial completely. So what you have is 2 or 3 other people testifying to what Mr. Ridge, a co-defendant, told them, and in some instances mentioned the defendant, Mr. Rakes. And seriously, there is very little else in this case linking Mr. Rakes to the crime. I think when you add the closing argument, and which was an issue that I addressed, and when you add the fact that the jury got the defendant's entire incarceration record, which was extremely prejudicial, I think you have a serious case of a substantial miscarriage of justice here. There was a homicide, there was a double homicide, and it took place in 1987. Statements were made before, a week after, 10 years after. And there were statements made and testified to by Mr. Condon that occurred when both Mr. Rakes and Mr. Ridge were incarcerated, at least 10 years after the incident. I don't believe this. I mean, I understand this court has ruled in some instances, and I'm referring to Winquist, where conspiracy occurred maybe 2 years after the fact. But in that case, they're writing letters to each other about actively burning a house down, and this court ruled that that would be definitely in furtherance of a conspiracy. We don't have evidence that after the incident, Rakes and Ridge were working together, concealing together, doing anything together, yet the Commonwealth was able to put in a statement that occurred 10 years, at least 10 years after the fact, I don't know the exact dates, but at least, when they both were incarcerated.
Does it matter that the murder itself was done to essentially conceal the crime? I mean, that the Ridge had said, these 2 victims knew me, so I had to kill them because I brought Rakes into it, and I got you into this, I'll get you out of it, and then he kills them. Does that matter in terms of concealment being a justifiable extension of the duration of the joint venture?
Clearly, Ridge told Trundley and Trundley testified to what you just said. And clearly he said, Rakes just did time and he doesn't want to do any more time. That's why I did it. But this is what Trundley said Ridge told him about Rakes. There's a lot of things that Trundley said that Ridge told him. Some of them included Rakes, some of them didn't include Rakes. I would ask the court 3 months after the fact, when Ridge tells Trundley that Rakes was involved with him, 3 months after, how is that a statement in furtherance of conspiracy? So I did it with Rakes. Okay, that's a statement, certainly hearsay. He's not concealing anything. He's not acting to conceal anything. He just made a informational statement. I did it with Rakes. Clearly damaging, but I would ask the court, how is that a statement in furtherance of a conspiracy? And then 10 years later, when they're in custody, Condon runs into Rakes and says everything is tight with him. But this court has never said conspiracies go that long.
Is there any limitation based on when the conviction's over, when the conviction is final? If the conviction's not final, would there still be room for a long-term conspiracy?
I don't understand the question.
Well, if there has been no finality yet, and statements come 10 years later between the two co-conspirators, but there's no permanent final conviction.
The case has not gone to trial.
No, it's gone to trial, but the conviction, and there's been a conviction, but it's not a final conviction because there's been no appeal. Can you still conspire in between that time?
This court has never said that conspiracies last that long, ever, that I see. I mean, unless...
Well, I guess I'm struggling with what makes a conspiracy limited. Is it the conviction? Is it mere passage of time? Is it finality? Is it the need for a conspiracy? Does a conspiracy go as long as one needs one?
This court, well, then it could go forever.
It could.
But this court has never said that, and this court has said it's not always time that matters. In Winquist, they said it is active participation, active concealment. And like I said, in Winquist, that was a letter that they were writing between each other, saying, "Let's burn down this house," because now that's pretty active. That's pretty straightforward. We're going to burn the house down. And the two of them were working together.
But isn't concealment of this conspiracy part of the conspiracy? I mean, if it hasn't yet been, if you haven't yet found out about it, why wouldn't trying to make sure that it doesn't get exposed be part of the conspiracy? And why would time matter?
I mean, I see what the court is struggling with, and I mean, my only answer to this question is if this court is going to say that statements in furtherance, statements by co-conspirators, and concealment certainly has been ruled a part of the conspiracy, goes until judgments are final, until everything is final, then we don't have a time limit on it, ever. But this court has never said that. This court has said that at some point in time, conspiracies end. And we have a case here that the evidence is not overwhelming. The evidence against Ridge might be, but the evidence against Rakes is just the statements of Ridge, well, statements of Trundley, and the statements of Condon about the statements of Ridge. And then you have the closing argument, which sort of, in my mind, just takes it another level with the Walpole records, which I understand the theory the Walpole records came in. They came in to show that he was in jail and he just got out of jail.
Now, you say they should have come in only in a very limited way.
Yes.
Wasn't there discussion with the judge about the limitations, though?
The judge did make a limit that they come in as to motive and intent.
Right.
The judge did say that. But look at what the records were that came in.
Were there any limitation on the records that did come in?
that did,
Yeah, I mean, were more offered than actually came in?
a lot more.
So the judge did limit what,
The judge did limit.
okay.
No, I
But
agree
not
with-
enough, you're saying?
Well, let me ask you this. If you were just going to bring in records to show that he was in jail, you could just bring in a record that said he was in jail up to 2 years before. So what they brought in, first of all, was the VAX movement sheet, which showed that he went to Walpole, went to Norfolk, went to MCI, went to about 4 other places.
So your argument is really it should have been limited yet more.
Yes, absolutely. And how
Suggested to the judge?
I think he objected. I think absolutely the defense counsel objected to it all, and some of it was excised, as Your Honor brought out.
After that, did the judge, did the lawyer suggest to the judge that the limitation was insufficient?
I believe so.
Okay.
I believe so. You have the next sheet over in the appendix where it shows his booking photo, it shows his fingerprints, it shows his conditions of parole, which say stay away from the victim, a victim, which tells, what does this tell the jury? That one, he's been involved in a prior crime that had a victim. It says drug conditions, alcohol testing, none of which have anything to do with this case. And it does show, fingerprints with a fairly mean and nasty booking photo. So my question is if you're only going to introduce that for that purpose, he was in jail, he got out. It could have been limited to that. And then you've got all these statements, which we just addressed, from Trundley, from Condon, from Sweeney, from Ridge, some concerning Rakes. Again, one of the statements is, Rakes did it with me 3 months after. Again, how is that a statement of concealment? How is that a statement in furtherance of a conspiracy? I don't see how that is. That's the argument there. And then 10 years later, everything is tight with, tell him everything is tight with us. 10 years later. So I guess the argument is that the conspiracy is still going on because concealment is still going on. And I guess this court could make that rule and expand the co-conspirator exception to the hearsay rule and just say, listen, it's infinite. But I don't think this court has ever done that. And I think the court has to ask, is this reliable? And then you have the
Is there a relationship between how long a co-conspirator rule can go and the statute of limitations on the crime that's being covered up?
Not that I ever saw. I mean, I understand what the statute of limitations is on murder, and that'd be forever.
Right.
Yeah. Again, the court can choose to expand that and say that, but I don't know that the court ever has done that yet. I'm sorry.
And what should be the limit?
Well, I think the court's language in Wincus where it says active participation should be a rule that this court should go by. And I would ask the court, what evidence was there after it's over that Rakes and Ridge even communicated? Again, Rehnquist, we got that letter, burn the building down. That's pretty active, but I don't see it here. I mean,
Well,
again,
if you
that's just
have, I
my-
mean, the latter statement you reference, everything is tight, the reassurance that I'm not talking, and therefore, if you thought that I was, that may induce you to cooperate, you should not. Is that not?
you certainly, I think the court is right and certainly could infer that. But again, the judge herself characterized that statement as ambiguous. Well, so Mr. Rakes did make an.
But she let it in.
She did let it in.
And what was her basis? So the defendant actually made a statement himself to Condon, which obviously would be an admission, and that statement was the other guy, nobody needed to die. The other guy shot him. The other crazy guy, I think she said, shot him. The judge in the motion for directed verdict
characterized that as ambiguous, and that being the only, quote, direct evidence against Mr. Rakes, other than all these other statements. Then you've got the closing argument where you got to, you know, the prosecutor says, you got to assume that everybody wore gloves because there's no fingerprints and there's no DNA. Well, first of all, there are a lot of ways to get DNA other than with your hands, and there was no evidence at all.
Did the fingerprint expert testify, as they often do, that we don't find fingerprints in every crime scene? You've seen the testimony, you've heard the testimony 100 times.
100 times.
Right. Was that part of this case?
I don't think so. But I should back off and say I don't remember reading that.
But even if, let's assume you're right, let's assume that that was an inference too far, how did it implicate Rakes? Why is Rakes worse off in the jury's eyes because he said they wore gloves?
Well, because that's an improper closing argument. He is arguing evidence of facts not in evidence.
He did wear gloves to wipe down the ammo.
And I put in my reply brief, there's no evidence that he was wiping down ammo with WD-40 prior to him going to this house. There was evidence that they saw him doing this on other occasions. Now, I did say in my reply brief that if they saw him doing it right before he went to the house, yeah, that's relevant evidence, and I assume the prosecutor could argue that. But he sees him do this on other occasions for whatever other reasons, I have no idea. But so we can take that and then infer that, okay, he was wearing gloves here, and not only that, Mr. Rakes had to be wearing gloves here, okay? And then we have to infer that he was begging for his life before he got killed, okay? There's no evidence that he was begging for his life, other than there was a gunshot in his hand. And now he's asking the jury to infer, well, his hands must have been raised, begging for his life. But what I'm saying is the Commonwealth is asking the jury to assume so many things that Mr. Rakes, one, they had to have two people because they had to hold down two people, that Mr. Rakes had to have known what Mr. Ridge was doing. And there's no evidence that Mr. Rakes knew any of this at all, other than all these statements that Rakes did it 2 months after the fact, and the other statements that we referred to. So I have other arguments in here, and I don't think I need to go into them now. And if the court doesn't have any questions, I'd rest on my briefs. But in summary, I just want to say that this case is troublesome because of the inference upon inference, the statements upon statements, and the closing argument, and the prior bad acts, which went way too far in this case, that I would argue would cause prejudice.
Prior bad acts meaning the admission of the prison records.
The prison records and the extent of the admission of the prison records, with an acknowledgement, as Justice Lang said, the judge did cut it more because there were also actually the actual charges were on there initially, and she did cut those. Thank you, Your Honor.
Thank you. Ms. Cusick, good morning.
Good morning, Your Honors. May it please the Court, Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth is asking this Court to affirm the defendant's convictions for the murders of Jay Slaughter and Heather Buchanan. Your Honors, I'd ask this Court not to adopt a limit on the time period in which a co-conspirator statement may be admitted. With respect to cases where there is a limit, there is a federal case, Grunenwald versus United States, which I believe is cited in some of the other cases. And in that case, there's a discussion of how extending the co-conspirator statement period could somehow act to extend the statute of limitations. Here, this was a murder, so there is no statute of limitations.
So no limits at all?
Your Honors, it's...
Time limits or no other limits?
Certainly, I'd suggest no time limit, certainly not in a case such as murder where there is no statute of limitations for the crime. With respect to other limits, perhaps there may be some some limits this court should impose in some cases.
Like what?
Well, Your Honor, in this case, I suggest there is no limit should be imposed. I would suggest in this case, the statements were properly admitted.
What about the one where I guess Ridge told Trunley that Rakes was involved 3 months afterwards? How is that in furtherance of the conspiracy?
In that case, certainly Mr. Trunley, there's evidence to indicate that Mr. Trunley was a co-conspirator with respect to the scheme to rob the house. Mr. Trunley found the address, Sweeney's address, provided it to Mr. Ridge, went on the trip out to sort of view the house with Mr. Ridge and their respective girlfriends, and also then called Mr. Sweeney when he knew that Mr. Ridge had indicated he was going out there, and lured Mr. Sweeney out of the house, and did receive some drugs from Mr. Ridge after the fact, and in fact had been told by Mr. Ridge, we won't have to live the way we've been living, we're going to get some money after we rob the house. So certainly Trunley was a conspirator, and he was not a disinterested party, and Mr. Ridge's statements to him were consistently to keep your mouth shut about this, you know what I'm capable of.
But what does that have to do with revealing that Rakes was involved in it? How does that further the conspiracy?
It's deepening the conspiracy, explaining to him who else was involved. When Trunley has a problem with somebody who's trying to collect money from, Rakes can help with that. He's the one I did Westwood with. Suggest it does indicate furtherance of the conspiracy, and certainly the conspiracy wasn't over at that point, not the concealment phase of it. Your Honors, with respect to the jail records,
Sorry, I'm not sure I get what you're saying as to why identifying Rakes furthered the conspiracy.
it was during the concealment phase of,
Right, let's assume we grant you that it was during the concealment phase. The question is, why does it further the conspiracy to tell somebody who may not have known who did it with Ridge, to tell somebody information that Trunley may not need to know? Why does that further the conspiracy for Trunley to know information that he did not know before and may not need to know?
it's in furtherance of the concealment, Your Honor. Here we have, again, Ridge telling Trunley, don't say anything about this, keep your mouth shut. And then when there's an issue of potential problems with somebody, Trunley needing help, he mentions Ridge as a person to be called, Rakes as a person to be called upon in those types of circumstances. I suggest it's part of Ridge's endeavor to keep Mr. Trunley from discussing what he knows with law enforcement and revealing the name of the other person involved, and that person is still around and available to help with something that might involve violence is part of that.
Now, at trial, was there an objection to the admission of that statement?
There were multiple objections to any statements that Mr. Trunley made that he attributed to Mr. Ridge.
And did Judge Fabricant articulate her reason for letting that in?
She allowed that in as a co-conspirator statement.
But did she address why?
I'm sorry, Your Honor, my memory's failing me on this. I believe there was multiple discussions of this throughout the trial, prior to the trial, in the course of the trial. And certainly this was, Judge Fabricant did review all of this in advance and review it, and it was an exercise of her discretion to allow it in. Your Honors, as to the jail records, certainly the judge did carefully review them, did redact the crime, the sentence. There was discussion of this, again, in an exercise of her discretion. She did make redactions, and she did give the jurors a detailed limiting instruction about the use of these, to suggest that certainly that was not an abuse of discretion by the judge.
But I'm trying to figure out, I mean, I know that it was put in and was found to be relevant because Rakes purportedly has said, I'm not going back to prison. So the fact that he had been in prison was relevant. But beyond that, why do we need to know which prison he was at or how many prisons he was at?
Your Honors, the trial judge did review the records and did admit them. Now, perhaps it could have been done differently, but here there was no abuse of discretion the way it was handled.
Okay, but I'm still not understand the relevance of, again, I understand the relevance of the fact that he was in prison, and he was in prison relatively recently, 17 days before the killing. I understand that in terms of identifying this person who said, I don't want to go back to prison. But it seems like you have a lot more than you need for that. That's what I'm trying to figure out. Why do you need all this stuff if that's all that you wanted in for?
Your Honor, the defendant's date of birth, identifying information to establish that it is indeed the same person as the James Rakes before the court, relevant for that, relevant to show that there was something for him to actually go back to, that it wasn't as if somebody had perhaps been held overnight on some kind of a charge. So I suggest it was relevant, and again,
So are you saying the gravity of what he did was relevant?
the
Why
underlying.
he was in prison was relevant?
No, Your Honor, but that he was actually, when he says, I'm not going back, that he actually had been
Well,
in
somebody could
prison.
have been back in for a little period of time, and that wouldn't be quite as much of a big deal as somebody who'd been there for a significant crime, doing significant time.
Well-
And the jury finds out that he's been there for a long time, right?
The records did indicate, I believe, approximately 2 years, so certainly that is a.
Nature of the crime that he was there for?
Your Honor, the judge did redact the crime that he was convicted of. That was redacted. The sentence that was imposed was redacted. There were redactions made to
What would the
these.
jury be able to tell by looking at the records, though?
They would be able to tell that he had indeed been incarcerated and the amount of time he had been incarcerated.
Okay.
And then they also had some biographical information, and they'd be able to determine with other evidence that it was the same person as was before them. Your Honors, with respect to the closing argument, in this case, the prosecutor properly asked the jurors to draw inferences from the evidence. Again, the evidence that the victim begged for his life, certainly I suggest that was a reasonable inference. The medical examiner,
So, but why is it relevant?
for the extreme cruelty and atrocity, Your Honors, to show that that was indeed, this situation was horrifying to these victims, that these victims were, again, wrapped in duct tape, and there's evidence of the conversation with Ridge, with Mr. Schlosser saying, we can go to the bank, no one needs to get hurt.
What are the objective facts that allow that inference?
The facts would be the statements from Mr. Ridge through Mr. Trunley that he had been talking to Schlosser the whole time, that Schlosser said, I can go to the bank in the morning or something to that effect, no one needs to get hurt. The tape that was torn, the tape on the coffee table as well as the marks around Schlosser's mouth suggested an inference that the tape had been at one point on there and then torn off. And also the gunshot wound, the through-and-through wound to the Mr. Schlosser's arm, and also that he had died from a gunshot wound to the head, and there was only evidence that there'd been 3 shots, so certainly that was one shot. And again, there was evidence that Mr. Ridge said that Miss Buchanan was shot first, and then Mr. Schlosser, the 2 victims were seated next to each other, and certainly Mr. Schlosser would have heard and felt Miss Buchanan being shot.
And the fingerprints?
There was evidence of Mr. Ridge using gloves to wipe down the bullets, and also that he kept gloves in the bag that he carried with him, which he was frequently and almost always seen carrying that bag. So certainly a reasonable inference that the gloves were in the bag that he had that night when he left when he told Mr. Trunley we're going to do it tonight. Excuse me. With respect to the prosecutor's remarks about Mr. Trunley, the defense attorney's argument was that he was a liar, a drug dealer, and a thief. I suggest that the prosecutor's response to that was certainly appropriate. And again, the prosecutor specifically called on the jury to say, this is for you to decide, ladies and gentlemen. So it's just there's no issue there. Your Honors, with respect to the closed courtroom claim, it was the trial judge who did conduct the evidentiary hearing on it, at which one of the prosecutors testified, the defendant's trial attorney and the defendant's wife testified. The trial judge did not find that the courtroom had ever been closed and explains in her memorandum of decision her reasons for that. to suggest that regardless of how the United States Supreme Court decides Weaver, the judge here did not find that there was ever a closure, so certainly there's no basis to grant a new trial on that basis. If there were no further questions, I would rest on my brief.
Okay, thank